So we're here on Cherokee territory. It's beautiful out here. It's beautiful. It's beautiful. Amazing. It's incredible. Standing with me here is a missionary. Now, you'll notice he doesn't have a license because this is Cherokee Nation. It's an independent nation. Independent nation. Independent nation. The Cherokee are an independent nation. But the state of Georgia requires that he has a license. To solve this problem, we're gonna have to go to the Supreme Court. The Supreme Court. Supreme Court. It's Worcester versus Georgia. It's Worcester versus Georgia. Worcester versus Georgia. It's the Supreme Court.
Bill Nye,
Supreme Court guy.
Bill Nye,
Supreme Court guy.
Bill Nye,
Supreme Court guy.
Supreme Court rules.
Bill Nye,
Supreme Court guy.
The year is 1832, and a Presbyterian missionary, Samuel Worcester, is attempting to minister on Cherokee lands without a license. Now, here's a map of Georgia in the 1830s. They didn't want Native Americans having sovereignty within their borders. So, in the 1820s and 30s, they began to take matters in their own hands and attempted to remove the Cherokees from their land. However, in 1827, the Cherokees established a constitutional government, declaring their independence as a sovereign nation that could not be affected or moved by individual states. The federal government recognized this Cherokee Nation through various treaty and protection laws. Now, you can understand how this would make Georgia very upset, so they attempted to extend their authority and jurisdiction over the Cherokee lands. So now, we've got a missionary, Samuel Worcester, attempting to minister on the Cherokee lands, and a state government who doesn't want to recognize the Cherokee Nation. So please, consider the following. Today on Consider the Following, we've got a missionary and a super duper Cherokee Nation territory replica of history! Now watch what happens when the missionary steps onto the SDCNTRH.
What?
If you look closely, you can see that he starts to become very close friend with the Cherokee leaders, advising them about their political and legal rights under the U.S. Constitution and U.S. Cherokee treaties. This allows him to become very influential in the Cherokee resistance movement. But the problem is, Georgia lawmakers have attempted to restrict this sort of work on Cherokee lands. So, when we add these Georgia laws into the mix, the missionary will be required to have a license. Required to have a license to minister on Cherokee lands. And take an oath, supporting the state of Georgia. Alas, not having either of these, he will be sentenced to a state penitentiary for 4 years. 4 years!
And that's the story of Jesus and the prostitute.
Ho! Ho!
Johnny! What are you doing?
Being a missionary to the Cherokees.
But Johnny, you're white! You know you can't be on Cherokee lands unless you have a license from the state of Georgia!
Well, can I have one then?
No, Johnny!
But you just said I had to have one.
I'm not going to give you one, though!
But how am I gonna preach without a license?
You're not! That's the point! Don't forget, you need to take an oath supporting the state of Georgia!
But that'll inhibit my ability to reach potential converts among the Cherokees. If I support a state that prosecutes the Native Americans living on their own sovereign territory.
That's the point! We don't want you getting any more supporters of resistance against Georgia!
Worcester claimed that Georgia had no right to require a license or mandate any laws of anyone on Cherokee land because they were an independent body formally recognized by the United States government. But Georgia saw the Cherokee as an Indian threat living on land within Georgia borders, making them subject to Georgia law. So essentially it became a contest between state law and federal law.
Worcester.
Georgia.
You have no right to declare law on Cherokee lands when the federal government has made numerous treaties with the Cherokees reaffirming their rights as a sovereign body.
But you have broken state law. You must do 4 years hard labor.
But federal law is higher than state law, as it states in the Constitution in Article 6.
Oh yeah, the Constitution says, this Constitution and the laws of the United States, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, laws of any state to the contrary notwithstanding.
So, what was the decision of the Supreme Court?
I don't know, Bill.
Take it away, Lin Hao.
Well, Bill, the Supreme Court's decision was really quite monumental. Chief Justice John Marshall ruled for the opinion of the court, saying that the Cherokee Nation was an independent community, as established by federal treaties. Thus, only the federal government was allowed to deal with the Cherokees, and not the state of Georgia.
Hi, I'm Andrew Jackson, and I'm the President of the United States. Well, the Supreme Court ruled in favor of the wretched Cherokees, but Georgia essentially decided to ignore the Supreme Court's decision and wouldn't even release Worcester from prison until January 1833, almost a year after the court's ruling. But you have to understand, Cherokee land is in big demand these days. Luckily, most unfortunately, I didn't really think there was much I could do to enforce the Supreme Court's ruling, seeing as how Georgia officials never formally acted against the ruling, choosing instead to ignore it and not put any action in writing. In fact, I was so much in support of the Cherokee Removal Acts that I negotiated 94 Indian removal treaties during my term of office. This included the highly successful and devastating forced move of 15,000 Cherokee to reservations in Oklahoma in 1838, known as the Trail of Tears.
Hey, try this historical experiment at home. All you need is an Indian reservation.
Okay.
For our lab, we're going to use Oklahoma.
What?
First, visit the reservation.
Second, try doing things you aren't allowed to do in the state the Indian reservation is in. Deal me in. Notice, you can do things that are legal in, say, Oklahoma, and they're not illegal in the Indian reservation because the federal government recognizes them as an independent body, so state laws don't apply. Thanks to Worcester versus Georgia, federal law and treaties are higher than state law in regard to Indian nations. Hit me. And that's how you win big. Thanks to Worcester versus Georgia, you can do whatever you want on an Indian reservation protected by federal law. And though the Supreme Court may be supreme, they don't have the power to carry out law. This is reserved for the executive branch, who makes the final call. Oh, Worcester versus Georgia.